Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Which court of law has the authority to take away your right to vote, your right to get married, and your right to decide where to live? I'll tell you, it's the court exercising probate jurisdiction here in Texas. This is Talk Law Radio. I'm Todd Marquardt. Now it's time to discover your legal issue blind spots by listening to me talk about the law on the radio. I'm talking about guardianship law today, and many people don't know how close their loved ones are to losing their rights to a guardianship. Now, most of the time, guardianship is used as a last resort in order to name somebody who's trustworthy that the court finds is going to be in the best interest of the ward. The ward is the person who is making bad decisions or neglecting themselves or isn't of age or doesn't have the mental capacity to make decisions. You may have known a family member or a friend or a neighbor who went through this court process called guardianship. It's a guardianship for somebody who's older, who's suffering from Alzheimer's or dementia or traumatic brain injury or lack of executive function in their brain because of some disease or trauma. If you have, you know how frustrated the family was in having to deal with it because it's expensive. You have to have a lawyer, and you have to get permission from the court to do everything. And so the court is going to supervise the guardian's care of the ward and how they use their funds. That's the accounting process until the ward's capacity is restored or until the ward passes away. So I'm going to be talking to you about some things that you need to know about guardianship. First of all, most people can avoid guardianship just by having estate planning documents like durable power of attorney, medical power of attorney, and directive to physicians. You might have a living revocable trust or other kind of trust where somebody has authority to make decisions, financial decisions for you in case you can't. The law calls those the least restrictive alternatives to guardianship. Guardianship should be a last resort. In fact, here in Texas, courts will not approve of somebody to be a guardian or to take away their rights unless you have already tried these least restrictive alternatives. And even if you do have a power of attorney, your loved one might end up in front of the guardianship judge. And so I'm going to talk about some case studies. I have a self-assessment that I can email to you. If you want this guardianship self-assessment for you or for a loved one, email me at host@talklawradio.com. That's HOST@talklawradio.com, and let me know where you're from, and in the subject line, just type guardianship, and I will reply with this self-assessment. On the self-assessment, it has some of these basic questions. Why do people say that the proposed ward is incapacitated? What's the medical condition or the legal condition that leads you to believe this person is not allowed to make their own decisions? Usually it's a medical condition like Alzheimer's, brain injury, mental illness, developmental disabilities, cognitive disability, or drug abuse. But if somebody doesn't have a parent, a natural guardian, then and they're under the age of 18, they're not allowed to make financial decisions because the age of majority, the age of consent, is age 18. Here's a scenario where a minor would need to have a guardian appointed. If a parent dies and the deceased parent left a life insurance benefit to a minor child, even if that minor child has a surviving parent, that surviving parent is going to need to apply to the guardianship court to be guardian of the estate of their child. Now, why is that, you ask? Because that money belongs to the child, and if the child is under age 18, they don't have the legal right to even accept the money, to cash a check or to deposit it into an account, because they're under age 18. They don't have the legal authority to do that. Well, why can't the natural parent just manage the money for the child? Because the law says that a natural parent owes a duty to provide for a home and shelter and clothing and food out of their own pocket. The child isn't responsible for using his or her own money to pay for food and shelter. And so the law wants to protect that child and that child's money by requiring guardianship. And in that guardianship, the natural parent is going to have to account to the court how they spent that money. And in the first place, they're going to have to ask for permission to spend it. Now, I know you think that's probably crazy or not understandable, but that's the law. And so if you don't want the natural parent to have to apply for guardianship, instead of naming your minor child as beneficiary of your life insurance policy, name a trust. Because you can name a trustee to manage it, and whenever you have a trust, there's no need for a guardian of the estate. Okay, moving on. The court would want to know, was the injury, disability, or death caused by an accident or a medical mistake? Is the proposed ward, the person who you're concerned about making bad decisions or neglecting themselves, is he or she substantially unable to make his or her own financial decisions? Is he or she substantially unable to make his or her own medical decisions? What problems have been happening that cause you concern? So when you petition the court to be appointed guardian, you have to have a reason. Other than this person being sick, what problems are being caused? And this frustrates some attorneys and some lay people out there because they don't want to have problems. Maybe they want to get guardianship to prevent problems. Well, there's too many guardianship cases in Texas, and so the legislators in Austin and the judges in Texas have decided that they're not going to grant a guardianship unless you have problems and unless you've tried other alternatives. Okay, so moving on. Some problems might be, is someone taking advantage of the incapacitated person? Is someone neglecting the incapacitated person? Is somebody hiding them away? Is somebody isolating them from their family? Has somebody physically abused your loved one? Has somebody financially exploited your loved one? These are all questions that the guardianship court is going to need to know. And specifically, they need to know what authority you need. Do you need to have financial authority or medical authority? Is the person able to take care of their own activities of daily living, but unable to make financial decisions, to write checks, to pay their own bills? I have seen situations like that where with a home care provider, they're able to take a shower with assistance. They're able to use the toilet with assistance. They're able to eat. But because of their cognitive deficits, they're unable to pay their own bills. They don't know how much money they have, and maybe somebody has already stolen money from them. So that's a scenario where it would be a partial guardianship, guardian of the person only. That's medical and healthcare decisions. No, I got that reversed. Be guardian of the estate, which is only financial and legal decisions, but they would still keep their rights to stay home if they want to. Are you worried about debts? There was a case one time where an individual with developmental disabilities was living on their own with assistance from their parent, who would come by and check on them. They were able to live alone, essentially. Well, some people took advantage of this disabled person by driving her to the car dealership, having her sign for a car loan that she couldn't afford. And she didn't know that she couldn't afford it. And so the guardian had to be appointed to take away that right for her to do that, so that she wouldn't be saddled with crushing debt. And so basically the guardian went down to the car dealership and said, I'm giving you this car back, and this person didn't have the cognitive ability to sign a contract to purchase the car or the promissory note to get a loan. There's been lots of other situations like that. I've been practicing law here in Texas for 19 years for Marquardt Law Firm, and Marquardt Law Firm sponsors the show. Attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, tax-protected inheritance plans, also probate court, guardianship court, and elder law, including helping people to qualify for government benefits to pay the high cost of long-term care. If you need an attorney, you can call Marquardt Law Firm at 210-530-4278, 210-530-4278, or go to marquardtlawfirm.com. That's M as in mother, A-R-Q-U-A-R, D as in David, T as in Timothy, lawfirm.com. Do you know how to use your estate planning documents? I've discovered after 19 years of practice not to take it for granted that people remember everything that they learned from their estate planning attorney. Even if you have a durable power of attorney and a medical power of attorney, you could fall into guardianship court. Here are some examples. Number one, if a bank or financial institution refuses to honor the power of attorney and you're not able to pay your own bills, then somebody has to go to the guardianship court and say, we've tried one of the least restrictive alternatives. We have a durable power of attorney, but for one reason or another, the bank won't honor it. They won't act at the direction of the agent under power of attorney. Another situation could be where a hospital or a doctor refuses to honor a medical power of attorney. In that case, you have to go to guardianship court and say the hospital or the doctor won't honor and take direction from the medical power of attorney. Sometimes this happens because of family conflict. There's been cases where there's competing powers of attorney. Say an individual signs a durable power of attorney in 2009, and then the principal, signs another power of attorney naming somebody else as agent in 2015. And the person who's named under the 2009 power of attorney thinks that they're doing the right thing by writing checks off of the bank account, and the person acting under the 2015 power of attorney starts writing checks off of the bank account. If the bank notices that the signatures are different, they might just freeze the account. And the bank doesn't want to have to decide which one's correct, so they just freeze the account. And you have to go to the guardianship court. Same thing could happen under medical power of attorney. There was a case one time where the principal, that's the person signing the power of attorney, named his two sons to be co-agents, to act at the same time with independent authority. Well, they acted with independent authority and didn't talk to each other about it. So one brother would take his dad out of the house and take him to assisted living, and the other brother would take him out of assisted living, bring him home, and hire home caregivers. You can see how that could create a conflict. Then they accused each other of stealing from their dad, and both brothers hired an attorney, and the attorneys were sending demand letters and filing court pleadings, alleging that the other one was doing something wrong. When I discovered, after looking through a grocery sack full of receipts and bank statements, that it appeared everything had been for Dad's benefit. How could all of those legal fees have been avoided? Well, I'll tell you. If you're not confident that you understand how to use the power of attorney and advocate for your loved one, then go see a lawyer, get some legal advice. These legal documents aren't just documents. It's not some magic wand that you just swing at somebody and say, hey, I'm the power of attorney, do what I say. Sometimes you need a little bit of legal advice to know how to do things, what to do, and what order. And so for those people, they might want to contact an attorney to find out how to protect their loved one from exploitation, how to pay bills properly, how to account for how the money's being spent in case somebody asks. You might want to know what are the duties of an agent under power of attorney. Well, the agent under power of attorney has a fiduciary duty, which is the highest duty imposed by law. Some of the duties include the duty to be loyal, to avoid conflicts of interest, to make sure that you're only doing the things that are permitted, that are written into the power of attorney document. And so there's pitfalls that you could fall into if you do something wrong, or just making a mistake. So you don't want to make a mistake. You hire an attorney and get some legal advice. Here are some typical scenarios. Here's a possible limited power of attorney situation. Imagine someone named Maria, fictional person, age 82, lives alone, been diagnosed with moderate dementia, and during the last 2 months, she left the stove on twice. Police returned her home after she became lost several blocks away. Sometimes takes a double dose of medication. Refuses assisted living because she believes her deceased husband is still living at home. Her daughter has a valid financial power of attorney, pays the bills, and no financial exploitation is happening. This would be a partial guardianship of the person only to make medical and healthcare decisions and to decide where she should live. Does that make sense? Let's look at another scenario. George, fictional person, age 77, has cognitive decline but handles routine daily activities. A new companion has isolated him from his children, and in 6 weeks, George has wired $85,000 to an unfamiliar account, signed a contract to sell a rental property for substantially less than fair market value, added a companion to his bank account that the family doesn't know, cannot explain transfers of money and believes that his companion is a bank employee and has no financial power of attorney. Well, that's an example of possible financial exploitation of an elderly person and probably needs to have guardian of the estate appointed. But maybe he can bathe himself, maybe he can feed himself, and so he doesn't need a guardian of the person. Here's another example. Ethan, who's about to turn age 18, just a fictional person for an example, with an intellectual disability, who reads at elementary school level, can express preferences and recognizes trusted people, can perform a part-time job with coaching, can manage a small weekly allowance, does not understand complex medical risks, leases, credit agreements, or benefits paperwork, relies on his parents to explain choices using simple language. This is somebody who might benefit from a supported decision maker agreement. This is another legal document, one that not many people know about, but it allows somebody with a disability to make their own decisions with the help of another person. So the other person isn't standing in the disabled person's shoes like what would happen with a power of attorney, but the supported decision-making agreement just lets banks, financial institutions, hospitals, and doctors know that it's okay to talk to and deal with this supported person. In this case, probably Ethan's parents. So that's good for you to know about. Another legal document that makes things easier in guardianship court is the pre-need declaration of guardian, to designate somebody who could be your guardian in advance of need. So it's something you sign while you're healthy and alive that says, if I needed a guardian, and I'm not saying that I do, but if that ever happens, I want, number one, my primary preference to be XYZ. Number two would be ABC. Number three would be DEF. And that lets the court know that they can presume that those people would be in your best interest, would act in your best interest. And here's another powerful part of the designation of guardian in advance of need, is you can name people that you don't like, that you think would try and steal your money or would try and neglect you. And that's what makes it really powerful, is it tells the court that these people would definitely not be in your best interest. They would be adverse to your interest. And so if a guardianship scenario comes up, the court knows if the preferred guardian is applying, the court can presume that they're acting in your best interest. And that saves a lot of the court's time, because part of the court order is to decide who would act in your best interest. And if you sign one of these in advance, the court already knows that. And so the person applying doesn't have to prove that they're an angel and they've never been in trouble and all these facts about why it would be a good idea for them to be your guardian. And likewise, the reverse is true. A court would not grant guardianship to somebody who you said would not be in your best interest. And so that's a very powerful document. If you have an estate plan, look in your folder, look in the envelope, or look in the binder to see if it's there. And if it's not, call your estate planning attorney and tell them that you want this. Well, I hope you've enjoyed the show. Remember that Talk Law Radio is also on Saturday mornings at 11 o'clock. Also, go to YouTube, podcasts everywhere, and talklawradio.com. I'm Todd Marquardt. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Most families don't realize they have hidden legal blind spots until it's too late. Wills, trusts, Medicaid planning, even protecting a business. These are the kinds of issues attorney Todd Marquardt helps uncover before they become problems. Todd is the host of Talk Law Radio, where each week he guides listeners through the legal challenges families, veterans, and business owners face, while showing them the practical steps to protect what matters most. Catch Talk Law Radio, Saturdays at 11 a.m. on 9:30 a.m. The Answer, 6:30 a.m. The Word, and now in Houston on AM 1070 and 103.3 FM The Answer, or anytime on YouTube. Planning isn't just about documents. It's about peace of mind, security for loved ones, and building a legacy that lasts. Don't wait for a crisis. Do it before you die.